Final case today, United States versus Hall. Mr. Gillison, be pleased to hear from you, sir.
Thank you very much. Good morning. My name is Edward Gillison, and I represent Joseph Hall. And, Your Honors, today we're faced with several issues. May it please the Court, I'd like to address them. I filed a pretty extensive brief in this matter. The brief contains 7 assignments of error that we believe occurred at the district court level.
There are some of them you didn't preserve in the district court.
Your Honor,
so you got a plain error issue on some of them, don't you?
that is correct, Your Honor. And I think that if the court would allow me, that perhaps I would start with those issues, because I believe that if the court can understand what the basis of that is, the court could probably understand why they were not able to be preserved at the district court level. I know that the court has already read the briefs and understands the basis of what the case was about, so I'm not going to go into that. But one area that I really would like to touch on is the issue with regards to the ammunition purchase evidence that was deemed to be intrinsic evidence, also found to be 404B evidence, and it was also evidence that was not disclosed to me prior to trial, so that I wasn't able to do anything. And I have 3 issues that are associated with that. The first issue associated with that, Your Honors, is the in-court testimony of Miranda Cordery. Ms. Cordery was the lady who was responsible for actually giving the sale or completing the sale of the guns.
She was the clerk.
That's correct, Your Honor.
And you say you didn't know they were going to introduce this evidence?
Your Honor,
I thought they offered it as 404B.
They did. But what was...
Didn't they tell you before trial they were going to present 404B evidence?
They did, Your Honor. But
and the judge said it's not 404B evidence, it's intrinsic.
Well, Your Honor,
it's part of the whole deal.
Well, Your Honor, he said that it's both intrinsic evidence, and if it's not intrinsic evidence, then it would satisfy the 404B.
It's admissible the way he looked at it.
Yes, sir. So whichever way we looked at it, the judge was going to let the evidence in.
But you're saying you didn't know it was coming. That's what kind of surprised me here.
Sirs, what I'm trying to say, or sirs and ma'am, what I'm trying to say to you is that I knew that it was coming, but I did not know that the person who was going to give the evidence was not able to positively identify my client out of court as being the person who was actually involved.
Well, you're talking about the identity evidence rather than the ammunition evidence.
That's the same thing. It was the same thing. The identity evidence was based upon the government calling this...
Well, the identity evidence was whether he was the guy that was in the store with the purchaser.
That's correct to a certain extent, Your Honor. The evidence that I'm worried about with the identification was that when Ms. Cordery testified in the court, that the first thing that she mentioned was the ammo purchase evidence with regards to my client being present with her. What I'm trying to say is that the record shows in this case that Ms. Cordery was the person who completed the sale. The sale of a gun at Cabela's requires that the sales clerk who sells the gun escorts the person who purchased the gun out of the store. The government presented that testimony at trial, and in it, she implicitly or explicitly identified my client as being the person who was actually involved with asking for ammo for the gun.
Was there really an issue about the identity? I thought
There wasn't.
There was the lady, the co-conspirator or the upfront purchaser or the straw purchaser, whatever you call it.
That's correct.
Identified your man too.
Yes, she did, Your Honor, and that's correct. She did identify my man, but for the issue of
your man admitted he was there too, didn't he?
He did, Your Honor. He admitted that he was there.
I'm not following this argument at all. If the identification testimony is fine, then you don't have any argument about the ammunition?
I do, Your Honor. I believe that.
What is it?
Okay, I believe that the ammunition.
No, don't talk about the identification unless it's necessary. What's the problem with the ammunition evidence?
The problem with that is, Your Honor, that the purpose for which the government asserts or argued that that evidence was relevant to the matter below was I never had the opportunity to object to its introduction based upon the fact that
all right, now you're objecting to it.
That's correct.
Tell us why it's not. You spent this whole argument talking about why it's plain error review rather than Preserved error? What's the error? You're in front of us.
That's correct.
What's the error on the ammunition?
The error on the ammunition is that it was inappropriate 404B evidence, that it was not reliable.
But the judge said it was intrinsic.
He did, even if it was intrinsic.
It was part of the transaction. They were in there to buy the guns, and they walked out of the store, they bought some ammunition
Correct. But
that fit the guns.
That's
Two
correct.
types of ammunition.
That's correct. But what my problem is with the purchase ammunition or with the ammunition purchase is that all of that happened after the purchase of the gun was done. And the government couldn't find any case, and nor could
Well, it
I
was on the
find
same
any.
visit to the store.
That is correct, Your Honor. But I believe what the case law provides is that if something is supposed to be so intertwined with the actual criminal act in and of itself, that it has to be a necessary preliminary.
Well, you just told us that Cabela's considers that part of the gun transaction walking the purchaser out of the store. It is part of the same deal. I mean, they walk them out of there because they can't go out of there with a gun and ammunition, or they can't be in the store with gun and ammunition. They don't want them.
That is correct, Your Honor, but the sale is basically completed at the point in which the sales clerk walks out of the store. Everything's done.
But before they walked out of the store, they bought the ammunition.
That is correct, Your Honor.
So the ammunition, according to Judge Stamp, was intrinsic. It was part of the deal.
I disagree
I
respectfully.
understand you disagree. So, but we review that, even if it was preserved, we'd review it for abuse of discretion, wouldn't we?
That is correct.
So here you're saying it's plain error. So we got that superimposed on it because Judge Stamp was never given the opportunity. Judge Stamp was never given the opportunity to assess your position on that.
Never. And the reason being was because the government did not fulfill its duty under
About
Brady
what?
versus Maryland to give me the prerequisite information that I need.
What is it they didn't give you?
They did not give me the information that the person who was going to be testifying about my client being the person who initiated the ammo purchase could not identify my client before
So that's
trial.
the identity. You're back to the identity information.
That's how it's all linked in together.
Yeah, but you said the identity thing is, there was no question about his identity.
Identity to being in the store. Identity to being in the store, we do not refute that. But the identity of being the actual purchaser of the gun and the purchaser of the ammo, we refute that.
All right, but what you're talking about, you're talking about the one photo show up.
Correct.
Single photo show up. And you didn't know about that until the trial?
Until the sentencing hearing. I knew
You didn't know about it until the sentencing hearing. But did you ever see the picture?
I didn't ever see the picture.
Did you get the Jinx Act material?
I did not get the Jinx Act material.
There was a Jinx Act order entered.
That is
to give it
correct.
to you 2 weeks before trial.
I did not receive that.
And then that order said, give you exculpatory information 2 weeks before the trial.
I did not receive that, Your Honor.
And you cross-examined about the identification.
I did.
And you cross-examined about the photo show-up.
I did.
Well, then why didn't you get it at the trial?
Because I did not have the information at trial.
Well, you had it at the trial. You were cross-examining the witness
That's correct,
at
Your
the trial about the very thing that you did say you didn't have.
That's correct.
So you must have you knew something about it, or you just stumbled on it at the trial.
No. What happened was, while I was cross-examining her, she then brought out the fact that I couldn't identify him. The picture was too grainy, was her
So you
exact
just stumbled
words.
on it.
Yes, sir.
Well, did you stop and say, Your Honor, I'd like to see what the records of this photo show up?
I objected on the record. I approached the bench. We went up to the
You
bench.
did, okay.
And I objected to the identification testimony.
Did they give you the picture then?
They did not give me the picture, but what happened was the judge made a ruling. The judge ruled at that time that the identification was proper. And that's what he was proper. That's what he said.
He's talking about the in-court identification.
Correct.
All right. What did you ask him for the picture and for the Jinx Act material?
I did
the
not.
Statement of the witness.
I did not, Your Honor.
But you had made a motion for that before the trial.
Well, in our district, Your Honor, that's something that's put in the initial scheduling
The
order.
rules have it.
And the rules
The
have it.
local rules up there say you have to turn over Jinx Act material.
That is
And you have
correct.
to turn over exculpatory evidence. And why don't they comply with those rules? They're going to have them.
Your Honor, I think that's what the major issue is. And I think that if my understanding of what occurred with regards to my Brady argument that I made was that the agent who had interviewed Ms. Cordery had knowledge that she couldn't identify him. But I don't know if he ever told that to the government. I know.
Well, but he's the agent of the government. He's a federal agent. He's not even one of these local policemen helping him out. He's the ATF guy.
I understand.
And he writes this stuff up. I'm just wondering why you didn't follow up stronger on it.
Your Honor, I went with everything that I could do with the resources that I had available. If it is error, how it's anything other than harmless error? I believe that it goes way beyond harmless error.
Well, it's what would make it harmless, or arguably, would be that you don't contest his identification. I mean, what it would be impeaching of the identification in court.
Correct.
That she couldn't identify him with the picture, couldn't be 100% sure. She said she was 90% sure, maybe. It was a grainy picture.
Let me ask, is that exculpatory?
I think it is.
Why is it?
It may
says,
not be
I'm 90%, the
exculpatory.
picture's bad, and I'm 90% sure that's that guy. That sounds inculpatory to me.
Well, Your Honors, I think if we looked at this in context of everything that happened below with regards to the trial and with regards to the witness testimony.
But she said, I'm 90% sure that's the guy, but that's a bad picture. That doesn't sound exculpatory.
Well, what she basically did, Your Honor, she only identified him in court. And I believe that the due process clause requires a little bit more than that.
She didn't qualify it in court. She said she identified him in court.
Yes,
but
it was only myself
that
and
was
her.
looking at him in court.
That's correct, Your Honor.
Well, there was no grainy photograph she had to look at.
No, she didn't.
Wasn't there testimony from the agent that she said, I'm 90% sure that's the guy, but the photograph is grainy. I can't be 100% positive.
I think there was something to that effect.
You mean the agent testified that at the trial?
At the sentencing hearing.
Right. I mean, but none of this came in the trial.
That's correct.
They had already had the trial.
That's correct. Your Honor.
Okay.
That's what the whole issue was.
But tell me again why is that exculpatory?
Your Honors, I think that if I would have had the ability to, first of all, know that there was an issue with regards to the identification in the beginning, that the preliminaries with regards to Judge Stamp's decision.
Wait a second. That's just you're saying if you had some idea there was some issue. The fact is, if you had some idea there might be some issue, that doesn't make it exculpatory.
Well, what makes it exculpatory is that
what?
even if we say that there's no issue with regards to the identity of my client being in the store, if the jury would not have heard the purchase of the ammo evidence, this is my position.
But it has nothing to do with the identification and whether or not her failure to be my question is, why is her failure under those circumstances to be 100% positive over a grainy photograph, but 90% positive? Why is that exculpatory that it draws into effect the Brady rule?
Because I think it raises the issue, and I think what it really.
I think you're stretching it to try to get to Brady, because you had an order that they have to turn over Jinx Act material.
Correct, Your Honor.
2 weeks before the trial, and the ATF man had written it up.
That's correct.
And that's a Jinx Act statement by him. Why didn't you get that? I mean, it's a Jinx Act violation.
Everything.
But you should have had it, but it's a Jinx Act violation, and the local rules up there say they're supposed to turn over that. They say they're also supposed to turn over Brady material. So if it's Jinx Act, this here arguably you got both of them. But you definitely have the Jinx Act.
That's correct. I think what happened.
But I don't see where it's anything other than harmlessness. That's what I can get at. You're going to have to show me how you're possibly prejudiced by any of it.
Your Honor, as all of you all know, 404B evidence is prejudicial in its nature. I mean, whenever you have.
Our precedent is it's a kind of an inclusive rule.
I agree with that.
We call it an inclusive rule. It comes in.
I agree with that. But you
if
still have law.
404B, it comes in.
You still have law that has to be followed with regards to the elements.
And Judge Stamp's characterization of it is intrinsic, because part of the whole deal.
That's correct.
It would be reviewed for abuse of discretion even if you objected timely.
I did.
I mean, it's hard to say it's not part of the whole deal.
But I think what happened.
That makes sense too. That it's part of it. He's in the store to buy the gun, and while he's in the store, he gets through a front person. He bought the guns, and then on the way out of the store, he bought some ammunition to use with the gun.
I agree with that, and I agree with that assessment of it. But what the problem is with that is that if you think that, Your Honor, then what do you think the jury thought? And what the jury thought is what's integral
Look,
in
the
this
jury
matter.
thought, we have to look at you went to trial on this, and we look at that in the light most favorable to the prosecution.
You can
They
still
thought
do
he
that.
was guilty.
Yeah, I agree with that. Guilty of that count. We did win the first
He
count.
won the
which was
first count. Well, he's guilty. The only one that went on appeal is that second count. And that he's guilty of that. They found him not guilty of aiding and abetting the false statement.
That's correct, Your Honor.
Can I ask you one question?
Oh, sure.
We've bounced around a lot, and you've reserved some time.
Yes.
And we've I've sort of
fine.
pushed your argument based on the questions I had. Would you just take a minute or two, maybe a minute? What do you think your strongest asserted error is? What do you think? What do you think the strongest argument of error is? Which issue?
Okay. First of all, I think that the strongest argument we have is the argument that I made about the 404B evidence and whether or not it was 404B evidence.
Okay.
I think that's my strongest argument.
Thank you.
However-
and you had a chance to make that. I just want to be sure.
Right.
We talked about your strongest. We have time on rebuttal. Thank you very much. Thank you very much.
Thank you, Mr. Gillison.
Thank you very much.
Mr. Perry? You were the trial attorney as well. Both of you all actually tried this case, as I recall.
That's correct, Your Honor. May it please the court, my name is David Perry. I'm an AUSA in the Northern District of West Virginia, and I was trial counsel in this matter. Your Honors, what happened here with respect to the witness is that during the
Talking
initial...
about the witness, store clerk?
Yes, Miranda Cordery. When she was initially interviewed by the ATF, that initial interview was perhaps not as thorough as it could have been. So it was actually during the trial preparation process that it was discovered that there had been a subsequent transaction involving ammunition. And it was during this subsequent interview during the trial preparation process that she was shown the photograph. So it wasn't a question of whether or not the agent had made a report of interview of it. There was no Jenks
Did he write up write a report on showing her the photograph?
He did not, Your Honor.
So there was no, you're saying he didn't even write that down?
He didn't write it up. So and there's no Jenks issue. The defendant hasn't raised a Jenks issue. Jenks issue would only apply to a recorded statement anyway.
Well, what did he do after he showed her the photo? He didn't make any notes?
Well, it was...
If he made notes, that would be Jenks material.
He didn't make any notes.
He made no notes. Did he make any notes on the back of the photo?
No, because the way it happened
Or on the front of the photo?
Essentially, it was an inconclusive identification.
He didn't write anything down?
No.
I've never heard of a federal agent throwing a lineup, a photo lineup.
Well,
Here, in this instance, one photo. That's a photo lineup, and not writing something down.
I think what he was thinking is, well, now I know that there was this additional transaction in which Ms. Cordery personally interacted with this guy. You know, maybe she could identify him. And it turns out she did, in fact, tell him, you know what, if I saw him again, I think I would be able to identify
Well,
him.
anytime you're having a one photo lineup, you're getting into a problem.
I understand
It
that,
means
Your Honor.
I think there are cases all over that say it's unduly suggestive.
I understand.
If it's a photo of particularly here, of a guy that's already indicted.
I
right?
understand that, Your Honor. And I think
Maybe that's why he didn't write it down.
That may be why I didn't write
I
it down.
did concede that in my brief, Your Honor, but that's not the end of the inquiry. I mean,
What he's doing is creating a problem for you.
I understand that.
You need to get the stuff written down and make sure that they have it in a timely manner.
When did he show the photograph to her?
It was...
It wasn't when he initially talked to her. Is that what you're
no,
saying?
it wasn't.
Let
It
you
was
straighten this out a little bit.
during the trial preparation process.
So you're saying what happened was the initial investigation, he just walked in and talked to her, didn't find much helpful, and he's just doing his sort of, I guess we call it preliminary, trying to gather information.
Exactly.
And then later in trial prep, somebody had the idea that maybe ought to talk to her some more and see what she did know. Is that
And that's
it?
a common thing for trial prep. You go back to the same witnesses and you interview them more thoroughly just in case you missed anything. He didn't even realize that there had been a subsequent transaction involving ammunition where as they're leaving the store, Ariel Underwood and the defendant turns around and says, oh yeah, I'm going to need some ammunition.
That's in the trial record. That's what's here.
Correct.
That's what she's testifying to.
Correct. That's
But
what happened.
You say in trial preparation, so how long before the jury was struck did this occur?
Oh, it was probably weeks, maybe a month. It was definitely long enough because I did submit a pretrial memorandum as to the admissibility of the 404B evidence. I don't know exactly off the top of my head when that was filed, but it certainly would have been before
Well, it seemed
that.
to me that maybe you'd have prepared and have the chronology straight before you walked in here today, maybe. Don't you think so?
Well, the fact is that the defendant was given notice of the 404B evidence, and he
Yeah,
did
no,
have
we
notice
know
of
that
the...
fact. We know that fact, but we'll find out some facts this morning we didn't know, and it seems to me it wouldn't be that difficult for you to anticipate. We might want to know the chronology.
And I would think that you'd want to go, and I second that, what exactly all that Judge Shedd said. But you got this suggestive one photo show up. You ought to get that on the record real quick and give the judge a shot at understanding that before you put the witness up there and have the witness finger the guy in the courtroom. Because you got to be able to prove at some point, if it's challenged, and the question here is whether they had a fair opportunity to challenge it or whether it's harmless error, but you got to be able to prove that court identification was not tainted.
Correct, Your Honor.
By the one photo lineup. I mean, they're much better off if they got 6 or 8 photos there.
Well, let me point out a couple of things, Your Honor.
But here you got one photo show up pre-trial
right.
that you didn't disclose.
Well, Your Honor,
So, I mean, that's,
actually,
if anything's Brady, it probably is.
Actually, Your Honor, the first 2 witnesses filed by the United States on December 7th and December 14th did indicate that this witness would be testifying as to identification.
But
Okay.
you know, I
Secondly-
don't necessarily want to pile on, but I just want to clarify this. So this one photo lineup was done for trial preparation?
It was in the course of the discussion.
Earlier,
Post-indictment. It was,
Yes, it was in the course of the
Post-indictment
discussion that the
preparation
agent had with the witness. But at the time, it was perceived as a non-issue because it was at best, or at worst, I should say, inconclusive. It wasn't a question of her recollection, Your
90%
Honor.
sure,
It wasn't a question of her recollection. It was a question of the quality of the
but it
photograph.
was a picture of the defendant. That's
Correct.
what creates the problem under those cases.
But suggestiveness is not the end of the inquiry, Your Honor.
but wait 1 second. No, but I don't.
No, I agree with that.
I don't think you're responding to what my concern is. My concern is not. I'm not talking about the results of the one photo lineup. I'm talking about the fact that it was done in trial prep. That seems to me that's bothersome to me because a one photo lineup is suggestive, but that was done in trial prep.
Well, the agent wanted to find out if this witness would be able to identify the defendant, as she said she would.
I know that, but the agent works for the government. The agent is charged with knowing the law, or you're faced with looking at the consequences if the agent doesn't.
I understand, Your
The
Honor.
agent is your agent.
I understand that.
He just does what he wants to do. Maybe that's true, and it tells you what he's done.
Well,
My
Your
gosh,
Honor,
don't listen. Those government agents don't get. They surely get training in something about basic principles of the law, don't they? Miranda rights and photo lineups got to be pretty close to sort of standard instructions to agents, shouldn't there be?
I'm not a big fan of single photo display.
Well, you
Your Honor.
shouldn't be. Neither are the courts. But the question is, your agent did it.
I understand that. Your Honor.
And let me ask you this: when did you find out it was done? After it was done, or before it was done?
I found out, basically, it was right around the same time.
Well, I'm not going to press you anymore, but I don't think you answered that question. You might be able to skate this time. I don't know, depending on the question of if it was material, but I don't know where the resolution would be if that issue was squarely in front of us. The improper out of court. I don't. If that had been raised by the other side, it's been raised lately about the improper out of court photo lineup. But gosh,
Well, the objection, of course,
that does not put the government's posture in a very good light, in my opinion.
Of course, now the objection actually made at trial was that it was cumulative.
That was what?
Cumulative.
I know.
And
You said it was cumulative? They said it was cumulative.
they said it was
Well, they
cumulative.
didn't know all about it. You didn't give him a Jinx Act statement. You didn't write it down. He says he didn't get the photo until the sentencing hearing.
Well,
You mean once they
How would you? Why wouldn't you give him the photo and tell him what happened?
If it's a
and let the
question,
judge figure it out.
if it's a question of whether or not it's a Brady violation, I'm happy to address that.
No, but the judge didn't get a chance to pass on it. I'm more concerned about the process here.
Well, the defendant
and
did.
how we end up getting here. It should be a Jinx Act situation that the agent wrote down his interview with this witness, which would include that picture. I gave her a one photo show up, and this is the guy that's under indictment, and lay it out there and let the judge decide whether it's proper or not, and then we got something we can look at.
At trial, Your Honor, I asked the witness the question, did you think you'd recognize the person if you saw him again? At that point, the defense did object, and there was a sidebar, and the judge did hear the defense's argument and decided that if the basis for the objection was that it's cumulative, then I'm going to let the inquiry proceed.
Right. Your point said the objection was cumulative. That was the objection once there was indication there had been some other attempted identification or something. Isn't that right?
Well, Your Honor, I think it's pretty obvious to everybody that this witness, if we just look at the big picture for a second, she has interacted with this guy on 2 occasions, 8 days apart.
Which witness you talking about, Mr.
Miranda Cordery.
She's the
2
clerk.
different days.
She's not the person that bought the gun.
Correct. She's
But
the
the person
clerk.
that got the gun said he's the guy.
Yes.
That's all the gun
Identification is not an issue. I mean, it's not
Right.
a legitimate issue.
said. And that's might be the saving grace for you.
It's
But
not a
you're gonna
legit.
you all are going to get another case where you mess around with these one photo show-ups, and you're going to foul something up.
It's correct that I really don't think there was any real issue as to ID at that point because Ariel Underwood.
Then why do you ask when we're in the courtroom, is he here? You had this Cordray ID him in the courtroom as the person that you sold the ammo to after showing her, not a lineup, but a show-up, one photo, post-indictment in
Your
preparation
Honor,
for trial.
because her
I mean,
identity,
just
she
on
was
those
able
facts, it
to
doesn't
make that.
You need to
Yes,
stop
Your Honor.
answering. Let him finish, and then you may talk.
Absolutely.
Kind of talked over. I didn't hear the end of
No,
what
that's
you
fine.
said.
That's fine. Did you understand what I was getting at?
Yes, Your Honor.
Go ahead and say whatever you answer, however you like.
Because she had seen him and interacted with him before, 2 different occasions, 2 different days.
No, that's why you asked her to identify him.
I knew she would
But-
have an independent basis for her recollection, Your Honor.
But the fact you wanted her to identify him makes it look much worse that you showed him a picture of him before showed her a picture of him before they got in the courtroom.
I thought you
didn't
didn't
write
know if
anything
she
down.
would have, I'm sorry, I thought you didn't know if she would have an independent recollection of him. That's the reason you gave for why the agent was preparing her with that picture to see if she would have an independent recollection of
We
him.
were taking a chance that she would recognize him, but I believe that she would have an independent recollection because if you look at the circumstances, she knew Ariel Underwood. They had worked together, and she had been trained on straw purchases. She was suspicious that this was
And
a straw
Underwood
purchase.
was the straw purchaser.
Yes. They worked together to accomplish this thing, which is called a straw purchase. The actual buyer of the gun is the defendant. So she sees them on the 19th of February when they first come in and try to buy the guns. Then she sees them again on the 27th of February when they actually complete the transaction. It's on the 27th where he turns around after the sale and says, oh, by the way, we're going to need some ammunition. She then has personal dialogue with this guy. She asked him questions, and he answers questions.
All that is good evidence for you. All that's good evidence for you, but all I'm trying to get at is how you potentially foul up that good evidence with a show-up of a picture of him that you don't write down and provide to the defendant in a timely manner.
That you did a month before trial, and the defense doesn't find out about it until sentencing.
Well, the question is whether or not it's material to the case. And
Well, that's not the question. The question, the local rules up there require you to turn over Jinx Act material 2 weeks before the trial or something like that.
Correct.
Judge Seibert entered an order to that effect in this case.
Correct.
And there should be Jinx Act material, I would think, for something like this.
There was
it's
no
a
written
significant
statement.
event in this case where you interview this woman who's going to implicate this guy and all this ammunition and everything.
I do understand.
And nobody writes it down. On the face of that, it just looks, it's funny, it's suspect.
I do understand your concern, Your Honor. I can only say that the Jenks issue is not before the court, and
Well, it's not before the court because you didn't write anything down. And you say the guy didn't even take notes, which doesn't make sense. I've never seen the FBI agents. I've worked with a lot of them, and they all take notes. Everything that they do, they got it written down somewhere.
I think, and I can't speak for him, but I think his perception was that she did identify the guy. She was 90% sure that this was the guy. It wasn't a question it was someone else. It was just a question of the quality of the photograph.
And they're entitled to cross-examine
And
the
he-
witness about the prior events
You're correct.
that might have some impact on what happened in the courtroom.
You're correct. And
Which would be that show up with that one photo before she came in. She
You're
was
correct,
shown a
Your Honor.
picture of the guy
You're correct, Your Honor.
and said
he
she was
did.
90% sure.
He did make effective use. He extensively cross-examined the witness about this prior display.
He did do that. He stumbled into it, as he said, because he had to stumble into it because nobody told him about it. But under the rules, he's entitled to be told about it.
Correct, Your Honor.
The way I read the local rules up there,
But it did come out.
Pretty-
He was
pretty
able to
broad
make
on
effective
discovery.
use of it. And I think that because of that, it can't be shown that he can't meet the materiality element.
well, you're arguing harmless error, basically.
No, Your Honor, it's not.
It is material, the cross-examination of the witness. He's entitled to cross-examine the witness on her prior statements about his client. And she made prior statements about his client to the officer, you say now a month or so before the trial in preparation. He was entitled to cross-examine her fully and fairly with respect to those statements. And then he was not provided with them because you say there are no notes made of them and the agent didn't write anything down.
Correct, Your Honor. May I respond to that?
Yeah, absolutely.
The standard for materiality is going to call into question whether or not this information, if disclosed, would have made a difference. The standard for materiality.
That's what I say. You're back to arguing harmless error. I'm telling you that there should be a Jinx Act statement, and it should have been turned over. And I think the ATF regulations require him to write that stuff down.
There's three
And
elements.
I think they require him to take notes and preserve them. And then nothing was turned over.
Your Honor, there's three elements for a Brady violation.
I'm not
One
talking
is-
about Brady. If I got there, I'd be very suspect of it, but I don't need to get there. There's a statutory violation. The Jinx Act requires the prior statements of a witness to be turned over before cross-examination. Here, under the local rules in West Virginia, northern West Virginia, they have to do it well before trial. And that's what Judge Seibert told y'all to do here, and he didn't turn it over here because you say nothing was written down. But there was definitely the prior statement made by the witness to the ATF agent.
Why do you sort of got crosswise in your arguments with the question? You were talking about a potential Brady violation, and I take it, just to get to the bottom of this, you say even if you accept it's exculpatory. Do you think it's exculpatory, yes or no?
Well, Your Honor, exculpatory
be a
means
yes or no.
either favorable or impeaching. And I'm not sure that it is.
Well, then the answer
because identification wasn't really an issue in this place. He identified
Let's
himself
move
on the tape.
beyond that then.
Yes.
You say it's not a Brady violation,
Correct.
even if it is exculpatory, because this identification question isn't material because there was enough evidence on identification that it's just not material, so it doesn't make a Brady violation.
Yes, you can't
Is
say
that
that
correct?
this. You
Is
can't
that
say.
correct?
Yes,
Is
you can't.
that correct?
Yes.
Now, why do you say the Jinx issue is not in front of us
It wasn't raised.
at any time?
I can only brief and argue.
What was not made?
No Jenks issue was raised. No Jenks issue.
The Jinx issue was raised but when he was arraigned, and Judge Seibert entered an order that ordered you to turn it over.
You mean on appeal?
Yes, no objection was preserved and no issue was
he
raised on
didn't.
appeal.
How can he say you didn't comply with Jinx when you didn't turn anything over under Jinx? Because you didn't make anything under Jinx. I mean, it's running the defendant in circles.
Do you say that because he found out, at least by the sentencing before this appeal, that there was a statement that looked like Jenks material?
Well, now Jenks contemplates a recorded statement.
What's that?
Jenks contemplates that the statement be recorded.
Jenks contemplates that something be in writing, which would include the notes of the officer,
Correct.
a FBI 302 or investigative report reflecting what the witness said, and you're representing to the court, as an officer of this court, that there's nothing in this case, none was ever made, which is, as I say, the fact that an ATF agent wouldn't in these circumstances is pretty astounding.
I think it was an impromptu situation, Your Honor, where he just decided, and then he realized that the photo quality was really bad, and I think he didn't think much of that.
But the fact that the witness was only 90% sure is a little different than her. That would be arguably impeaching. The fact that if he could have shown that he was only 90% sure when they showed him a picture,
Slightly.
she's 100% sure in the courtroom, that's a little bit.
Slightly and marginally.
There's an inconsistency there.
Slightly and marginally, yes, Your Honor, but she did testify in the courtroom that the basis for her recollection was his ears.
But both of you seem to agree there was no question of his ID anyway. He was the right person.
And in fact, the defense...
Because Underwood said that she confirmed all that.
In fact, the defense
He did
admitted...
himself, as Judge Shedd pointed out.
May I respond, Your Honor?
Oh, sure.
In fact, in closing statement, the defense indicated that he wasn't contesting the issue of identification after he had hotly contested it throughout the trial. And he said, and I quote, "My client and I don't contest that. We're trying to sit here and tell you that it wasn't him in the video, and that wasn't him on the phone call. We don't even want to try and tell you that. I just wanted to make sure that you all knew that we're not trying to say that wasn't me with the big D on my hat."
So your point is that it's harmless error if it's error.
Correct.
And only point I'm making is I wish you all be careful about this kind of stuff. I've been on the other end of this argument, standing pretty much in the same courtroom. And there's no reason in the world for the government to risk a potential good case over something like this.
I understand your concern. Thank you, Your Honor.
Like you. Mr. Gillison?
Your Honor, just a couple matters of clarification. I don't want to take up much of your time. I appreciate you all listening to me today. I know this is a very important issue in front of the court, and I appreciate you giving me the time and the pleasure of arguing this. Your Honor, the simple fact is that I did everything that I could humanly possibly do with the resources that I had at the district court level. With
I don't know.
regards
Don't be apologizing for what you did or didn't do. Why don't you just make your legal argument?
Okay. My legal argument is that I simply did not have this evidence. I did not have it. I did not have it. As the government has said, we didn't contest identification. I mean, my client was the one who was in the video. We already know that. What we're talking about, Your Honor.
Let me ask you this. When did you first find out, you first find out that Ms. Cordray had been asked, had been shown had some other question and been shown a photo of your client?
At the
photo that purported to be your client.
At the sentencing hearing that occurred 2 months after trial.
What did you find out at trial when you cross-examined her? What did you ask her? What was that discussion about?
That discussion at trial was after she said that I was not sure about his identification.
Right.
Then I asked her why not.
Right.
And why she was not sure.
And she said what?
And she said because she was not 100% certain at the time that she was interviewed that that was the person who was in the photograph. I did not have a photograph at that time.
No. And you answered, so you knew on cross-examination that she had seen a photograph?
I did, Your Honor.
Well, I'm just asking you.
I did.
Did that raise concerns of an out-of-court lineup?
It did, Your Honor.
Did you raise that with the court?
It did, but I didn't get the opportunity to raise it because the issue pre-trial was not known to me. I did not know.
No, but you knew it then.
I did, and I...
Did you not say, Your Honor, bench conference?
I did.
What is this, an out-of-court photo lineup? I don't know anything about it. Did you say that?
Your Honor, I didn't say that specific language.
What did you say?
But I believe that the record shows that I did raise that issue initially with regards to the improper in-court identification. And as the government has said, as I will concede...
Improper in-court?
Right, in-court identification.
Yeah, but improper in-court identification has different components than out-of-court improper photo show-ups. They're two different issues.
I agree with that, Your Honor. And
Well,
I tried.
but you didn't raise. You said, listen. You got up and said, I did everything I could. Okay, I take you at your word. I wondered. Now I'm asking you, why didn't you, when you found out on cross-examination that witness had been shown? It sounds like she'd been shown a photo at some point. Why didn't you raise the objection, say, Your Honor, what is this about a photo lineup? When did that happen? Why didn't they tell me about it?
Your Honors, I believe I did.
You
I may
said
not
that.
have went into those specifics, but I believe that I did mention the photo and the fact that it was improper for the improper identification.
So why didn't you find out before the sentencing then? Did the judge not require him to give you any more information?
Not after that. That's the main reason why I called the agent at the sentencing hearing, because I was trying to get testimony on this record for this court to be able to review it.
Did you ask him questions like I asked about, did he have any notes or anything like that?
I did, Your Honor. I asked him about it.
He said he didn't have any.
He claims that, I believe the record will show that he claims that there was an interview and a report that was done, but in the report that was actually done, there was no mention whatsoever as to about the lack of identification or the lack of uncertainty about the
Was there
photo
anything about a
identification.
photo being shown?
Nothing at all, Your Honor. There was a report.
Did you ever see the report?
I saw one report. I saw the initial report, and I also asked on cross-examination. One of the issues that was raised below was whether or not this report could be admissible, and that's a sidebar issue.
Do you purport that the photo ID, the photo lineup show-up was done at the first interview? Do you have any reason to think that?
That's what I believe, Your Honor, with all due respect, but I know that that was not provided to me to where I could have addressed that issue pre-trial or even during the
Did
trial.
you understand there was a
cross-examination.
second interview closer to trial when there was a photo show-up?
I believe I did find out some information with regards to that, but I did not find out about the second interview until the sentencing hearing. And that was when I was able to find out that the government's agent had knowledge that she was not able to identify it. So therefore, that knowledge was imputed to the government.
No, but you had knowledge of that from her testimony, you said.
I did, Your Honor, but I didn't know the extent of what I didn't know is I didn't know when she had told somebody else about it. I didn't know when. I didn't know if she had told someone about it.
And you said to Judge Stamp, clearly, there's been a photo lineup outside of this courtroom that I know nothing about.
Your Honor, I cannot say that I used that definite language. I can only tell the court that with regards to preserving that objection, I believe that I did the best objection that I had at that time available to me based upon the information that I had. I thank each and every one of you all very much for my time.
We thank you very much. You're court appointed in this case?
Yes, sir, I am, Your Honor.
Well, we appreciate the work that you and all the court appointed lawyers do.
Thank you
help
very
us with
much,
these
Your Honor.
cases. We'll come down and Greek counsel and adjourn court. Sine die.
This honorable court stands adjourned. Sine die. God save the United States and this honorable court.